recognized explicitly, noting that the text of the Constitution, which grants authority to the states, and our tradition is squarely on our side in this case, which is why this was a unanimous decision, and we thus avert the potential spectacle of a bribed elector, as we talked about, of even an elector voting for Frodo Baggins. This was an important decision. It removes the uncertainty that otherwise would have ensued, and it is a great relief to have this decided well in advance of a presidential election, so we're not arguing about these rules knowing who benefits or who hurts from these rules. Again, our team put in incredible work, and you can see the work in Justice Kagan's opinion, which tracked many of the arguments that we developed, made before the Supreme Court. We did this as a team, and it was great working with the Secretary of State and her office. She's committed to managing elections that are stable, predictable, and honor the will of the people, and that's part of what this case was about. So let me turn it over to her, and then we'll take your questions.
Well, I just think this is a great decision. We should be really happy about it. And just as one other thing that Colorado is doing to lead on democracy, at a time when we're seeing voter suppression, the undermining of rule of law, I just think it has been so fantastic working with Attorney General Weiser to make sure that the basic concepts of our democracy are protected and remain in place. And what this case is really about is a recommitment to our fundamental rights to vote, to have our voices heard in the presidential election, and also the recommitment to states' rights, to be able to enforce state law so that a few unelected electors, presidential electors, cannot undermine every single voter in Colorado and every single voter across the nation. I do think that as we see the emergence of voter suppression and different tactics to try to chip away at the foundations of our democracy, we have to remain steadfast. And whether that's calling it out when we see voter suppression in other states, whether that's improving our system or even taking a fight all the way to the Supreme Court, that's what the Attorney General and I are going to do. And I'm just so proud to partner with him and to work with him. And I also want to thank our team at the Secretary of State's office, our elections director, our comms people, but also former Secretary of State Wayne Williams. The Attorney General and I adopted this case from the previous administrations. We've worked very closely with Secretary Williams. We had planned to go to DC to see oral arguments and cheer the Attorney General on. Of course, COVID sidestepped those plans, but he was one of the first people that I contacted this morning. And I know he is just very happy at the results. And it just underlines his commitment to the case, the fact that we had amicus from all different states of all different political colors, that this case really is about protecting the institutions of voting and making sure that Americans can have a say in who the president is, which is just so important to our democracy.
All right, we've got some questions teed up. Mary Ann, you're first. Maybe I need to call on you here.
Thank you. Got it. Good morning. This is for Attorney General Weiser. I've spoken to both Polly Baca and Bob Demanik this morning, and they both cited the same thing, which is they believed in a premise of one person, one vote, and claimed that that binding their votes is unconstitutional on that premise. Can you respond to that, please?
I can. They made that argument before the Supreme Court, and what it gets to is, who is the voter? Is the voter the elector who deserves independent discretion, or is the voter the people of Colorado who view electors as proxy voters? And Justice Kagan talked about it and said there are lots of voters who don't have independent discretion but are proxy voters, and the opinion says that's the type of voter an elector is. So I recognize what Polly Baca thought it meant to be an elector. What the Supreme Court said is, no, that's not what it means to be an elector. Electors are guided and structured by state law, and they can be set up as proxies representing the people. And that's what the Supreme Court said here today. I can also get Andrew Kenny's question, who said, does it eliminate elector rebellions? And I think by that he would mean rogue electors or electors who would basically do whatever they might want? And the answer, and this is a flip side of Marianne's question, is yes. This case says electors who thought they had independent discretion, like Polly Baca, are now told, no, they don't. And if a state wants to bind them to the vote of the people of that state, a state has the authority to do that and can remove them if they refuse to act as called for by state law.
And I think that point is so important, not only because the Attorney General and I also believe in one person, one vote. We believe in the votes of Coloradans and Americans being counted in the biggest election of our land, but also because of our emerging concerns about the corruptibility of electors. The fact is that Russia and other countries continue to try to undermine our democracy, either by direct attacks on our election systems, ransomware attacks, or disinformation campaigns. And the ability to create a deepfake video or bribe someone is just exponentially easier with the social media access that we have. So state laws binding electors are just so important to make sure that, frankly, it's harder to run disinformation campaigns. It's a lot harder to have to trick lots of people, millions of people, hundreds of people than one or two electors. And I was really happy to see the Supreme Court in oral arguments lean into that because we must fight against any type of potential corruption, especially when it comes to the bedrock of our nation.
Marshall.
I have a question for one each, but let me start with Secretary of State. We were talking in interviews, we had talked about, does anything need to change on the ballot? Do you need to see the candidate you're voting for and the 9 electors you're also voting for? Because state law can change in the future in terms of binding an elector, does anything need to change with how your ballot looks in presidential years?
Well, I think generally no. If we would have lost, absolutely. Because the major concern was a couple of rogue unelected electors undermining every Coloradan. So that's definitely something that we were considering. We were also considering running statute that it was a felony, making it a felony to bribe or corrupt an elector. But I do think that the Supreme Court just reaffirmed Colorado state law, and the state law says that the elector must vote for whoever wins the most vote in Colorado in the presidential election, to clarify. So I do think that we are in a really strong spot with this decision.
And Attorney General or Frodo Baggins, I need to ask you, Colorado got slighted, in my opinion, of the opinion of the court. Colorado is referenced twice on the same page, and it's mostly about Washington. Do you feel like Colorado got fair share of this case?
Marshall, the only person who didn't get their fair share is Frodo Baggins because he played a prominent role in oral argument. But in the opinion, Veep comes up, the Hamilton musical comes up, but there's no talk of Frodo Baggins. So in all seriousness, we are a team here. Washington and Colorado work together really in a highly collaborative way. Our briefs were able to complement each other. So our arguments were able to complement each other. And the big difference was Sotomayor was recused in the Colorado case, which is why this was a contemplated outcome, that the Washington decision would be the main event, and we would simply see the earlier decision, which is what happened, a per curiam decision, which is see the earlier decision. The court could have determined that any of the different issues warranted a different opinion. We had issues around standing to bring a suit in our case. We had a removal in our case. They had a fine in their case. Ultimately, it wasn't a close enough case for those issues to matter. It was a very clear constitutional case that was able to be decided with all 9 members in the Washington case. And I'm thrilled to be along for that because our arguments were absolutely translated into the opinion in that case. Let me jump to Spencer's point because it was actually just what the Secretary of State was talking about, which is as we move ahead and history and technology is changing, is there more worry about rogue electors being swayed in ways that could be problematic? And I will first echo what the Secretary said, which is absolutely, we are seeing elections that are closer. So look back over the last 20 years, we're seeing more close elections. And when you have close elections, you have more room for error. And as, again, the Secretary of State said, that means more room for extortion or bribery. And what happened in 2016, where there was this movement to try to do this, was a greater degree. And the court recognized we had more faithless electors in 2016 than in a century. So I do think the risk here was growing, and it was, as the Secretary said, a great result to have that risk be dealt with. Anything else you want to add to that? I know you've already talked about that, Jenna.
Well, I would just say, I think it's important that other states reflect on their laws. We know disinformation campaigns are in the top concerns for this upcoming election and future elections. So Colorado law specifically binds the electors to vote for whoever wins the most votes. Many states have similar laws. There are a couple states that don't. And they, of course, can look at their laws. And I will add on to the Attorney General's previous answer about how does it feel that we only got a couple lines? I will say that without Colorado appealing, there would have been a less likelihood for the case to even be considered in the first place, because Washington had actually won their case in the lower court, where the state of Colorado and my office lost our case in the lower court. So we necessarily had to appeal to get the momentum going. And I've just been really happy to work with the Attorney General and the entire process to make sure that we are stopping election eve litigation or Electoral College eve litigation and just reaffirming our deep commitment to our democracy.
Before we get to Ray's question, let me answer Blair's question, which once again is the flip side of something the Secretary of State talked about, which is, do we need additional measures, fines or other measures to prevent rogue electors? And I think what the Secretary said is exactly right, which is the fact that we won our removal authority at the Supreme Court is all we need, because there is no better way to address rogue electors than to remove them before they can violate their state law duty. So we have the authority under current law that we need. It's been upheld. I don't believe we'll need any other measures. Let's go to Ray.
Hi, Ray Solomon, KUNC. I kind of want to pile on Andy Kenny's question and then Blair's question. You were able to remove the elector, Michael Baca, because he announced beforehand that he was planning to go rogue. If an elector does not announce beforehand that they're planning to go rogue, is there still a possibility that their rogue vote could be counted in the Electoral College?
Let me mention this, and then Secretary of State can follow. What happened is he did announce it ahead of time. So did two others, by the way. The two others were told, if you attempt to cast an illegal ballot, you will be removed and prevented from doing so, which is kind of like trying to cast a ballot without signing it, which is required under state law. And that attempt was not followed through by, for example, Polly Baca, who did vote as required by state law. But when Michael Baca attempted to cast an illegal ballot, he was removed and replaced with someone else. So that precedent would follow. If anyone attempted to cast an illegal ballot, they would not be allowed to do so, and they'd be removed and replaced with someone who casted a lawful ballot. So I don't see, let's call it, any daylight or wiggle room in this opinion.
That's exactly right. So the question really becomes, and the question that Secretary Williams was faced with, is a ballot cast in violation of Colorado law a valid ballot, like the Attorney General is saying? And the answer to that is no. So if we were in a situation, again, where a presidential elector decided to defy Colorado law, that would not be a valid ballot. They would be replaced to make sure that Coloradans can ultimately have their voices heard. People believe that their votes count in the presidential election, and that's what the Supreme Court just reaffirmed. A state can dictate through state law that the people will be the influence on deciding how electoral votes go. So I am incredibly committed to that. I will not allow presidential electors to disenfranchise Coloradans. And very luckily, our law also says that. The Attorney General agrees. So I do think we're just in a really good situation in terms of casting the presidential votes when we reach that point.
Let me go to Megan, Megan, then back to Marshall.
Can you hear me now?
Yep, you're coming through great.
Here we go. Sorry, I was talking and wasn't unmuted. Wondering if you see this as possibly a disincentive in the future for people to be electors or to try to take on that role.
I don't, Megan, because there were electors, Mary Beth Corsentino, for example, and she wrote a brief to the court saying, we signed up to support the people of Colorado. This is a real honor and a privilege to be representatives of the people of Colorado. It is a symbolic function, but symbols matter. And the Electoral College in Colorado, the Colorado electors, are reflective of our constitutional democracy, playing this valuable role. So for people like Mary Beth, they still want to do it. Electors who had other ideas, well, they can dismiss those ideas because they're no longer viable. To the extent that had been an open question at the Supreme Court, it's now been answered. All right, Marshall?
Does anything in this opinion give you guidance for what the Supreme Court might think about national popular vote if that ended up in front of the Supreme Court?
This opinion is pretty clearly about this case. I think the basis of the opinion is state discretion and state authority. And so I think that would apply in other contexts as well. But I do believe this opinion was really crafted around this issue and that there's a series of other legal issues that would be up for grabs in the national popular vote. Anything you want to add to that, Secretary of State? Or?
Yes, absolutely. So the National Popular Vote Compact is about state law. It's about various states passing a law and they becoming active when enough states opt in. So to the extent that this case reaffirms the ability of states to regulate their electors, I do think it is related, right? So it would be the same case that if national popular vote were to go into effect as state law, we would then enforce state law.
We have Jesse Paul. And Jesse, thanks for being the pool reporter and reporting on the actual argument. As Janet said, we weren't able to do it in the actual grandeur of the Supreme Court, but we were able to have you recounting what it was like here in the Attorney General's office.
Yeah, and thank you for the opportunity for that. I guess along the lines of Marshall's question and the national popular vote, obviously this gives us the ability to states to, regulate how, the presidential electors cast votes. What's to stop the Colorado legislature from saying that presidential electors can only vote for Democrats or can only vote for Republicans now?
This is an important point that Jesse raises, and we made a very important qualifier in our argument, which the Supreme Court adopted, and there is a constraint on what states can do insofar as they can't violate other constitutional constraints. And one of the constitutional constraints that we talked about is once people cast their vote under the right to vote cases, they can't later be told that their votes won't be counted. And so if people vote for a Republican for president, they can't later after the fact be told, oh, sorry, your vote doesn't count. Now, your question, Jesse, could involve people being told up front, your vote is merely advisory, or your vote is even not even advisory, it's just empty. I think that would be an unfortunate move from the legislature, but the legislature has plenary authority, and as long as it doesn't violate an independent constitutional division, the legislature has flexibility. In fact, the legislature could appoint the electors themselves if they wanted to.
I slightly, I'll say, we'll give a nuanced response from the Attorney Generals. I think we would likely go back to the Supreme Court if that would happen. The Solicitor General of Washington in our sister case argued that once the people have the right to vote, a state and a government cannot take that away. And I agree with that. You cannot step on people's voices once they have the right to vote. Every American has the right to vote in a presidential election. And if a legislature would try to overstep to that degree, there would be lawsuits. And again, we would be fighting for all Coloradans and all Americans to have their voices heard. I think we would win that case too. And I just, by the way, that's very unlikely, extremely unlikely to happen in Colorado. But if that does happen in other states, that would be a further attempt of voter suppression, and we would fight it.
I agree with that. I think the harder question, which is also a sort of law school hypothetical, is what if even before people voted, a legislature tried to limit who could be an elector? That has been so ahistorical. We've never seen anything remotely like it that I don't think we will. But clearly, I totally agree with Secretary of State. Once people have voted and a certain candidate is chosen, to be undone by the legislature would create a constitutional challenge that I believe would succeed. All right, we are waiting for other questions that people may have. Let me quickly note that I do share the esteem and appreciation for our former Secretary of State, Wayne Williams, who worked really hard on this case. And it's worth noting the decisions they made facilitated us being able to win the way we did. They set this case up for ultimate resolution at the Supreme Court. They developed the principles extremely well. And I will say, Wayne Williams believes deeply in that people's votes have right to be counted. And the work that he and Jana Griswold have done in leading our state as a model is something really to be proud of. All right, Blair has a question.
All right, hi guys. Kind of along the lines of things that are somewhat unlikely to happen, but everybody's asked other good questions. But the decision does make a carve out there where they didn't rule on what could happen in the event of a candidate dying in between the election and the Electoral College. Just curious to get your thoughts on what might happen there should that be the case.
I did address this in the argument and happy to share the same analysis, which is we have a constitutional amendment that speaks directly to this, that says when a presidential nominee who's elected dies before Inauguration Day, the vice president shall become president.
All right, cool. That's it.
All right. Last call, and then if people have more questions later, Lawrence is available. If there's a statement from both the Secretary of State and myself. Jenna, any final remarks you want to make?
Well, I would just say thank you again, Phil. It's been, as always, great to continue to work with you. I will say that the one thing we're not focusing on is the crisis averted. A lot of times it's, more focus is on the actual crisis than the aversion of the crisis. But if we wouldn't have pursued this case and if we wouldn't have won, there could have been chaos on the eve of the Electoral College. A secondary campaign ran just for the electors, bribery from our enemies and in foreign countries trying to sway the election, and undermining in the belief of our nation. And if there was not this litigation, open litigation on political questions before the Supreme Court. So it really was an aversion of a democracy doomsday. And I just think it's great that we've gotten ahead of it, that people know what the rules are, and there's one less risk going into this presidential election.
I'd second that point, and it's worth underscoring the lawyers who worked on this case, from our Solicitor General, Eric Olson, and Assistant Solicitor General, Grant Sullivan, head of our Public Officials Unit, Leanne Morrill. They were extraordinarily thoughtful about how the timing would work. And this is to the Secretary of State's earlier point. We managed this timetable to get this before the Supreme Court, to get a decision without the presidential election itself depending on this decision. And again, we saw in Bush versus Gore what a spectacle that can be. This was an orderly process of the case being briefed in a normal order, being argued and decided, and we are delighted with this decision. All right, thanks everybody.
See y'all later.